just finishing exhaustion of domestic remedies before the short adjournment, the last legal point. And before we leave it completely, I just wanted to deal with a sentence each on two of the authorities the club cites. Those are O'Keefe.
Sorry, you're going to have to speak up a tiny bit.
Yes. Before we leave exhaustion of
I don't think that microphone's going to help you. It's not a microphone.
No, it's not a microphone issue.
It's a recording device.
Before we leave exhaustion of domestic remedies,
yes,
there were just two authorities the club relies on, which I wanted to deal with a sentence each.
Okay.
And those are O'Keefe, authorities, volume 5, tab 53. We don't need to turn them up, just for your note. And we say that's not a relevant authority.
Tab 53, not 55.
53, yes, sorry, that's what I had written. It may not be what I said. Apologies. That is about not having to pursue multiple remedies, but being able to choose that which addresses the essential grievance when you are the individual pursuing all of those remedies. We say it's not on point.
Yep.
Because here no remedies were pursued by the club against its liability. And the second is CNAR, authorities, volume 5, tab 41, which is about not having to make use of a remedy which cannot deal with the relevant complaint. So there the remedy was reviewed by the same cassation court, and the applicant had raised his complaint before that same cassation court. We say it's not on point because one of the remedies here was an amparo appeal to the Constitutional Court, which is obviously a different body. I can move on to the factual background. I'll take this speedily, but I'm conscious that the club did not take you to many of the documents, and there are a couple which are important. There are 7 key stages of the Spanish proceedings to have in mind.
7 key stages.
Yes, but we're not going to go to all the documents, you'll be pleased to know. I just want to give you the structure so that when I come to the complaints I can be quick. The first is obviously the Spanish Provincial Court judgment. I don't ask you to turn it up. Mr Young, who's very conscious that patience is golden, will deal briefly with any factual matters arising from the specific reasoning in the 2 judgments, if the court would be assisted by that at the conclusion of my submissions. But this judgment followed a long and detailed trial, 9 months, 115 witnesses, 82 experts. You have that from the UN decision, paragraph 1.2. And we know that the club declined to appear. The master was acquitted of the serious negligence against the environment offence and convicted of the offence of disobedience. Civil liability for the pollution was not imposed. It could not be said that disobedience had caused the damage of the oil spill. Then you have the Spanish Supreme Court judgment on the appeal against the conviction, which was not attended by the master, but it was attended by his lawyers, but again, not by the club. We know again from the UN decision, paragraph 2.3, the Spanish Supreme Court reviewed 118 folios, and it substituted the conviction for serious negligence against the environment. This was an offence of risk creation, which did not require damage. It then moved on to civil liability, which did require damage, and imposed on the master and the owners vicariously civil liability in excess of the CLC limit, because Article 5.2, which was in one of Mr Hancock's notes, was satisfied. Intent to cause such damage or recklessly and with knowledge that such damage would probably result. And they did that because, and this is all in the context of the civil liability, the master had caused the damage which ensued. He had been seriously negligent against the environment. The owners deliberately took risk in deciding to send the vessel on its final voyage. And the club was then had civil liability imposed directly under Article 17 of the Penal Code, up to the limit in the contract of the insurance because of the breach of the CLC limit. Now, the only references I'm going to ask you to note for the Supreme Court judgment are, my Lady Justice Andrews referred yesterday to the sections which deal with arbitrariness in that judgment. I think it's pages 36 to 39 of the internal pages. And Mr Hancock says those were not relevant to this part of the case because the court was not reviewing the rationality of the lower court. Of course, that's right. The club isn't asking you to review the rationality of the lower court. In fact, the club's complaint is with the Spanish Supreme Court's findings. But what I would say about it is that it is a very careful exegesis of the principles of rationality. And it does show that the court had the principle of rationality and the need not to produce an arbitrary and unreasonable decision well in mind in its own process of reasoning. I would also just ask you to make a note of pages 31 to 35, passages in the legal framework immediately before that, which are relevant to the new facts ground the club advances, because in those pages we see the court acutely aware of all the Strasbourg jurisprudence that my learned friends cite about not making new factual findings on appeal, and it's acutely aware that its constraint is the facts as they've been found by the provincial court. So those are the first two stages. And then we have a liability. The club says, oh, well, we couldn't have done anything at those two stages because we needed the liability to arise. But we then have the stages where there is a liability, where the club still doesn't participate. The third stage is the nullity application, petition, which is made to the Spanish Supreme Court, so the same court. And you have the dismissal of the petition in the core bundle. And you have the at page 267, you have the application that's made to the Spanish Supreme Court at supplementary 12. And I think it is just worth looking at what complaints were raised so that you can see the identity. So that's supplementary volume 12. Tab 59. Sorry, that's the decision. Sorry, 58 is the application. No? Sorry.
I think it's 57.
It's 57, maybe, thank you. So, you see on the second page, 3037, at A, at the top, reference to the fundamental right to due process in the Spanish Constitution, 24.2. One of those guarantees is the right to defence and the right of confrontation, principle of immediacy and evaluation of evidence in relation to Article 6, ECHR. And then if you follow that through, you see 3038 at the bottom, below the second hole punch, by carrying out this process of re-evaluation and reassessment of facts. That's the complaint. And then the complaint is articulated over the following pages. You see at 3040, lots of the Strasbourg case law that's now cited in the new findings case, 3040 at the top, the aforesaid judgments. You see Iguacol, Garcia Hernandez, La Pasadena Calero, which are all the same cases the club cites now. And the complaint runs on to page very detailed submissions about all the ways in which the provincial court, the Supreme Court, has gone wrong and going beyond the findings of the provincial court. It runs all the way up to page 3061. And then at 3061, we see the Article 1 of the First Protocol complaint. So this is a complaint by the master about A1P1 civil liability. Because it's the secondary consequence of the earlier finding of criminal guilt with regard to a crime against the environment. So it's subsidiary. The complaint is because the reasoning involves new facts being found. It's a breach of Article 6. It's also, in consequence, a breach of Article 1 of the first protocol. And then we have if you could just leave bundle 12 out, if we could then go to core supplementary, which is the Spanish Supreme Court's response. It's tab 20. So we see on page 269 is the articulation of the legal grounds of the petition. 1, infringement of the right to due process, Article 24 of the Spanish Constitution, also Article 6 of the EJEC. And then it says, due to this Supreme Court having reviewed, re-evaluated and reconsidered subjective elements of the offence, the allegation is the court reviewed and re-evaluated the specific behaviour in order to establish whether or not he acted imprudently and furthermore with serious negligence. And then a description of why that is prohibited. And then at 2, breach of Article 24 of the Spanish Constitution in relation to Article 1 of the first protocol. And then over the page we see the articulation of that complaint in relation to the civil liability, secondary consequence of the prior criminal conviction, breach, and that's the articulation. And then we see the conclusions in relation to those complaints at 272. The incident of nullity of proceedings as filed must be dismissed. The reference there with the first legal ground, new factual findings, clear reference to jurisprudence of the European Court of Human Rights, and top of page 273, adheres at all times to the facts declared proven in the lower court judgment, does not introduce any change whatsoever to those facts arising from any new assessment of the evidence produced. And that reasoning carries on until 275. Again, at the top of that, solely and exclusively altered the juridical classification, third sentence, established by the court. This is something the court is able to do without infringing the fundamental rights of the accused. And then the finding in relation to the civil liability, to the alleged breach, must also be dismissed. So those are the complaints that are raised there. We then have the Amparo appeal. Again, those same references, complaints are made. The references are supplementary bundle 12, tab 58 this time. And it's page 3111 to 3144. It's the same breaches of Article 6 rights, and then breaches of A1, P1 rights in respect of civil liability. That's 3144. And it's right to say that it was a condition that the appeal be of special constitutional importance. And it's also right to say that the Constitutional Court dismissed the appeal because it didn't display special constitutional importance. And you have that at 59, tab 59, 3201. Then you have the European, so those are stages 3 and 4. Stage 5 is the Strasbourg decision. Yes, obviously the Constitutional Court is a higher court to the Spanish Supreme Court. That Amparo appeal was a route available to a higher court. Then we have the Strasbourg decision, which alleged breaches of Article 6 and breaches of Article 1 of the first protocol. And that is, the application is at supplementary 12, again, tab 60. And page 3207 it starts, and the description summary of the claim is at 3214. At the top, the applicant submits the Supreme Court acted in breach of Article 6 when it overturned his acquittal on appeal, thereby reaching new factual conclusions, introducing new theories of causation, and reaching new conclusions regarding the subjective elements of the offence. And then over the page.
So which page you are?
3214.
Oh, 3214.
3215. A1P1, the applicant submits the Supreme Court judgment which found him civilly liable for all the damage that resulted from the oil spill amounts to an interference. By convicting the applicant under a procedure that violated Article 6, the Spanish state failed to ensure a process that was in compliance with the convention. And then I just take you to where those complaints are articulated in detail. 3225 is where the Article 6 complaint is articulated, all the way up to 3235. So again, a lot of detail about all the ways in which new findings of fact are said to have been made. And then the Article 1 first protocol complaint is at 3239. If I could draw attention in particular to paragraph 97, the Supreme Court's reasoning is clearly in 3239, paragraph 97. The Supreme Court's reasoning is clearly and obviously flawed, finding that the applicant should have been...
find the page.
I'm sorry, 3239.
3253.
Thank you. We don't have your page number.
Internal.
Yes, sorry, internal page number.
Thank you.
So the complaint at 97 is that the reasoning is clearly and obviously flawed. The finding that he should have been aware of the risk does not justify finding that he was aware of the risk. Unfair for the Supreme Court to reach a conclusion of that state of mind without having evidence, and so on. So this is a complaint about the nature of the reasoning and why it is flawed. Then there are also, the European Court dismisses the application, and it's worth going to this because of the correspondence which follows.
It declared it inadmissible, it didn't dismiss it, it declared it inadmissible.
That's right, my lady. It's in the core bundle, I think it's in two places. It's in the core bundle, core supplementary bundle, at page 307, I think it starts.
Core supplementary.
Yes. 307 in my bundle is the inadmissibility decision. Tab 26. So that's the letter saying that it is the subject of a single judge formation.
Mm-hmm.
And it's been decided to declare it inadmissible, and then the decision is enclosed. The decision is on 308. Single judge formation has examined the application as submitted. Application refers to Article 6 and Article 1, Protocol 1, finds that in light of all the material in its possession, the matters complained of do not disclose any appearance of a violation, thereby manifestly ill-founded within the meaning of Article 35. Now then on 319, there is the letter from the club, well, from the master, solicitors for the master, which sets out why they consider the decision of the single judge to be so extraordinary and so obviously wrong, bottom of page 309, that it must be a mistake. They say it should never have been considered by the Andorran judge. And then they make submissions about the context of the application and what findings were made by who. And they say that the Supreme Court at 311 made its own fresh findings of fact again. And then they repeat their arguments at 312 with the case law about new factual findings. And they make a point at 313 about the failure of the judge to recuse himself and why they say he should have recused himself. And then ask for the decision to be annulled at 314. And they get a short response at 316. Then they write again, 318. And then Spain writes, I think in the meantime, the application to the UN committee is filed. And Spain writes a letter explaining 321, it says, 322, it says that there has been an application made before the UN Human Rights Committee, and it explains what has been, I think, the admissibility proceedings, and really what it gets to is that there was a question over the extent of review which the single judge has given the application. That is relevant. You see at 322, the lawyers openly cast doubts and openly discredit before the UN committee the impartiality and the seriousness of the analysis carried out by the European Court of Human Rights with the following argumentation. And they include reference there about on 323 at 7, in particular, the extremely limited reasoning contained in succinct terms of the court's pro forma letter does not indicate that the single judge's examination included sufficient consideration of the merits, which is one of the requirements for a complaint to be inadmissible before the UN Human Rights Committee. And then again over the page at 324, the failure to provide reasons regarding the decision to declare the application inadmissible is clearly procedurally unfair, etc. And Spain is essentially saying, if you could clarify, last paragraph on page 325, much obliged if the court could forward to us a certificate regarding that a thorough analysis on the merits of the case has been performed by the registry and the acting single judge before deciding on inadmission. This would be used to back our pleadings on inadmission of this claim before the UN Human Rights Committee in order to contradict the assertion that essentially there's been no review of the merits. So what follows is the letter at 326. Which explains 326, third paragraph. The court is unable to provide the parties with more elaborate reasoning for single judge decisions, but I can explain the background to the court's processing of such clearly inadmissible cases. And that is what they do over the page. In particular at 327, under the heading Reasoned Decisions, they say from June 2017, decisions take the form of a reasoned decision signed by the single judge. The reasoning is expressed in standardised language with a maximum of 3 reasons per application. In adopting the new approach, the court has had to strike a balance between addressing a legitimate concern about the lack of individualised reasoning and maintaining an efficient process for handling inadmissible cases, so as not to divert too many resources from examining potentially well-founded cases. This is why elaborate or detailed reasons are not given. The decision in the present case, following the new practice direction, is a reasoned decision by Judge Villanova specifying the grounds of inadmissibility after a full analysis of the facts of the case within the meaning of Article 35. And then the complaint about the Andorran judge is dealt with over the page at 328, alleged lack of impartiality. They say that under the rules of court, the situations where a judge may not take part in consideration are prescribed. There was no reason for the judge to withdraw from the case because Andorra is a neighbouring state to Spain or France, because that's not one of the criteria in the rule. So then you have the UN admissibility decision, which Mr Hancock says is neither here nor there. All I say about that is it finds the complaint under the UN convention that's made about new factual findings inadmissible because Strasbourg has looked at it. So you'll see consideration of the Strasbourg reasoning there.
does
paragraphs.
inadmissible mean?
Inadmissible.
My lady said, well, it wasn't a dismissal, it was inadmissible, but it then said at page 308 that there was no violation. Why does the formulation inadmissible used rather than not permitted or dismissed or not allowed or whatever?
So it's a decision under Article 35 of the rules, which provides a basis for dismissing.
Article 35 of the Convention.
I believe it's yes, under the Convention. Yeah.
Where do we find that?
That's tab 9
Of
the bundle 1. Volume 1. And it's page 84.
page 92 of the,
Right.
91 to 92 of the bundle. Admissibility criteria.
Yeah, that's right. And it's 3 that they deal with it under. 3A. The court shall declare inadmissible any individual application submitted under Article 34 if it considers that A, the application is manifestly ill-founded.
So it's a strikeout.
Yes.
And it said manifestly ill-founded.
The meaning of that expression is explained in the decision itself. It's not quite what you think it is. It doesn't, I suppose if we translate it into English norms, we'd call it failure to raise a prima facie case of a violation of a given right. It's about the nearest you can get to it.
Is that what you say, Ms. Patel?
So, sorry, I was on the...
Miss Patel
Do you-
did nod.
Oh, I'm sorry, I agreed.
You agreed? Okay. Thank you.
So, yes, just the references to the admissibility decision, just for your note, 6.3, paragraph 6.3 and 6.4 of that decision. They consider what Strasbourg has done. It's page 338 of my bundle. In fact, maybe it is helpful. I'll just read the sentence. The committee needs to determine whether the author's other claims under Article 14, 1, 2 and 3 constitute the same matter admitted before the ECHR can be considered to have been examined by that court. The committee recalls its jurisprudence, according to which when the European Court has based a declaration of inadmissibility not solely on procedural grounds, but on reasons that include a certain consideration of the merits of the case, however limited, then that same matter has been examined within the meaning of the respective reservations to Article 5.2a of the optional protocol. The committee takes note of the author's argument, according to which the succinct ECHR decision does not indicate that the single judge's examination included sufficient consideration of the merits. However, the committee notes that the ground put forward by the ECHR inevitably implies a certain, although limited, consideration of the merits of the case. The committee further notes the letter by the European Court of Human Rights indicating that there has been a consideration of the merits of the case. The committee is therefore satisfied that the European Court went beyond an examination of purely procedural admissibility criteria. And that is the basis on which that factual findings aspect of the complaint before the UN committee is dismissed before that committee. And the only part that goes forward to the final decision that Dub relies on is the Article 14.5 complaint about the right to a higher review. Now, that decision is in the core supplementary bundle of tab 23. I just want to make 2 points about it. The first is on page 288. I don't think it's in dispute, but it's reflected at paragraph 4.1 of the judgment of the decision that Article 14.5 is not a complaint that was ever raised by the master at any stage in Spain. And it's a point Spain makes. At 2.3, and the committee endorses at 4.1. But effectively, because that point wasn't raised at the admissibility stage that you just looked at, the committee says it can't look at it at the merits stage. So although that might have been a reason for not allowing the case to go forward to a merits hearing, because Spain didn't raise it at the relevant stage when it should have been raised, the committee decides it won't look at it at the merits stage. And then the committee decides that the reasoning about whether there has been a violation of Article 14.5 is from 5.1 onwards on page 289. And the key paragraphs are really 5.4 and 5.5. The committee notes the argument of the state party according to which the judgment of the Supreme Court found the author guilty of a reckless offence against the environment does not contain a review of the proven facts, but rather limits itself to a review of the legal evaluation carried out. The committee notes the argument of the author, and then there's a reference to the European Convention on Human Rights, Protocol 7, Article 2. The committee says that's a different treaty, different formulation of the right to Article 14.5, but Article 14.5 doesn't have the exceptions that that provision of that treaty has. Spain hasn't put a reservation on Article 14.5, and they have to guarantee the right regardless of Article 2 of Protocol 7. And then at 5.5 they go through what their assessment of what happened is, and halfway through that paragraph they say regardless of whether the Supreme Court introduced new conclusions of fact or only evaluated legal questions, so not giving a view on new factual findings, the committee notes that the author was found guilty in the second instance proceedings for the first time of a crime of which he had been acquitted by the lower court, resulting in greater penalty, and he did not have the possibility of his guilty verdict and penalty being reviewed under the terms of the covenant. Now, what is absent from that analysis is any analysis of whether that particular complaint, the new findings complaint, could have been the subject of an amparo appeal, for example. There's discussion of amparo appeals at 4.3 on page 288. The author argues neither the appeal for nullity nor the amparo appeal would have been effective remedies. The Constitutional Court has affirmed on numerous occasions that the internal constitutional right does not guarantee the right to a review of a guilty verdict in appeal proceedings after a guilty verdict. And then only those remedies that should be exhausted that have a reasonable prospect of success, that's the interhandle test, and talks more about its jurisprudence. But what it's talking about there, it's saying that in its view, the Spanish Constitutional Court does not provide a right of higher review of the type that the UN would like to see, generally, in respect of all appeals. But what it doesn't look at is whether, if your complaint is new factual findings, in fact, because of the way that right is protected under the Spanish Constitution, in fact, an amparo appeal could be a proper remedy. And there are two cases in the bundle in my submission which show that the amparo, are cases where the amparo route has been successfully invoked by an appellant, where there have been complaints of new factual findings made. So, what do we take from that? At each step of the way, the complaints about human rights are made by the master in respect of violations of his own rights, apart from the 14.5 complaint, which he never raises. And the club doesn't participate at any of those 7 levels, seeking to challenge the breaches of its rights that it says flows from the findings of civil liability, which is it says is parasitic on the criminal's conviction. And that is a point that is a theme throughout the judgment of the learned judge, and we say he was entirely right to give the attention to that factor which he gave it. If I can then try and move quite quickly through the three complaints. I hope I've now covered a lot of the territory. I can be relatively brief on the three complaints. So the first one is new findings of fact. And
what the Spanish court said it did was it used the old findings of fact, but it looked at the legal consequences of those findings of fact.
That's exactly right, my lady.
And so it's a bit like saying the tribunal below found X, Y, Z, A, B, C was only negligence and not recklessness, and the appeal court looks at it and says if you add those all together, they do amount to recklessness as a matter of law.
That's
as I understand it.
That's exactly right. And that's a process which the Strasbourg case law permits.
That's what?
That's a process which the Strasbourg case law permits. Legal evaluation. So, if I can give you...
Where does the judge say that? 124.
Well, he refers to one of the...
Is that 1241 and 2?
No, at this point, my lord, we're in the section of the judgment that runs from, it's what he treated as ground 2, so it runs from paragraph 69 to 88.
Okay.
I mean, at 88, he addresses the Botten and Norway case. Maybe it's more helpful if I could take you to the closing submissions, because what you have from the club are, at paragraph 18 of their skeleton, a recitation of the case law that they put before the learned judge below. We have not done the same in our skeleton, but you can see the cases, and you can see the bottom case which the judge refers to at paragraph 88 in the closing submissions, which are at supplementary 4. Tab 17. So at tab 17, which is Spain's closing submissions below, at Appendix B, page 998, sorry, 997, at paragraph 39, you see the club's cases, which it relies on, which say that you can't make new findings of fact, paragraph 39, and then you'll see many of the cases there overlap with the ones which are in their skeleton for this appeal at paragraph 18. And then at paragraph 40, Spain cites a number of other cases in which the court did not find violations. And you'll see there a reference to Bazo Gonzalez, which is in the bundle. I think it's tab 48. And then several others, all of which, the theme in all of them, you'll see the text in Bazo Gonzalez. The Audiencia Provincial had examined aspects which were predominantly legal in nature following a first instance trial. It's the same 1, 2, 3, 4, 5, 6, 7 lines down in the second case. And the same, all of those cases are cases which involve paragraph 41. These cases show that the assessment of whether there has been a breach of Article 6 is inherently context-specific and involves asking whether the task of the appellate court was predominantly legal in nature. So that is the case that was advanced by Spain. And we say when you understand what the learned judge was doing at paragraph 85 and 86, he is effectively applying that analysis. Is it a legal classification of a different offence on the same facts, or does it involve new factual findings? And Mr Young can address you on the detail if it's of assistance. So the three heads that the judge decides new factual findings on, which I went to at the outset, where the complaint is about breaches of the master's rights. That's paragraph 75 of the judgment. And he says, the club is seeking to rely on alleged violations of rights conferred on a defendant through a criminal charge, specifically the master. It's not relying on its own rights. And the rule as to not making new factual findings on appeal does not apply to civil proceedings in Spain. So it's a difficult complaint to run in relation to a case where Spain says there have not been new factual findings in the criminal section of the judgment. There has been a reclassification of the criminal offence, and to the extent there's been a finding of damage, for example, in relation to the civil offence, it's in the civil proceedings, and the rule on new factual findings doesn't apply there. So he says, therefore, it's problematic to rely on the rights of the master, but for the club to raise this complaint when it depends on the rights of the master in a criminal conviction. He then also says at the end of that paragraph, the club did not assert any rights it had itself, did not take any steps, the point about non-exhaustion of remedy. So we say that he was entirely right to take that approach. And Mr. Hancock, I think, cited one case, Pogyosin, in his submissions handed up this morning. I think it's paragraph 32, which he says is an illustration of an Article 6 violation leading to an A1P1 violation. We say he's not on point because in that case it was the applicant whose rights were being violated in relation to both of the complaints. Here, obviously, it's not the case. You've got the master raising Article 6 and the club raising A1P1. The approach to the European Court of the Strasbourg decision is his second reason for rejecting the appeal. That's paragraph 76 of his judgment and onwards. He goes through, in those paragraphs 76 and following, to 80, exactly the same allegations for the subject of examination by the Spanish courts and the ECHR. He refers to section 2 of the Human Rights Act, and then he addresses Smith and Huertas and Interdesco. Now, what does he say about that? The club says, oh, well, you can't rely on Smith and Huertas because it concerned an ECHR application ruling against the party resisting enforcement himself rather than resisting enforcement of a derivative judgment. But if you look at paragraph 77 of the judgment, the learned judge is expressly recognising that the ECHR application is made by the master and concerns his rights, not the club's. But he's saying, he's making it clear that the rejection of the master's complaint is relevant because the club is invoking the claim that the master's rights have been violated. So that is why Smith and Huertas is relevant. You see that at Judgment 83. I had wanted to turn up Smith, but in the interests of time, I'm not going to. Can I just, I think it was on the pre-reading list, can I just, if the court hasn't already, ask that the court looks at it, because it is clearly on point, and it raises the impermissibility of challenges to findings at various paragraphs, 39, 45, 57, 61 to 62, 64. There are all references to the preclusion of review, Article 36, and why certain matters are things that the court can't look at. And then it also talks about the failure to raise a particular violation in the state of origin or Strasbourg as being a problem, a separate problem. That is the answer to Smith and White. As we say, the judge's reliance on it was sound. I've addressed the fact that it's a single judge decision. The judge also took into account the complaint about the Andorran judge. And then the third complaint about new facts. I've addressed you on the relevant law, and the broad point is that it was a legal classification. And if you look at the paragraph where the evidence is dealt with, 85 and 86, that is what the judge is concluding. You can see that from paragraphs 73 to 74, the judge refers to the elaborate argument of the club, the extensive expert evidence devoted to this issue. It's clear that he has considered everything that was put before him in reaching that conclusion. And moving on to the second limb of the challenge, the absence of a higher review. There were three bases on which I mentioned this was rejected by the judge, and that part of the judgment starts at paragraph 51. You see at paragraph 55 the treatment of the not being part of English public policy aspect. And then at 62 he says even if it's English public policy, it's not relevant public policy. Then at 63 he says, oh, it's the rights of someone else. And then at 68 he deals with not appearing in the Spanish proceedings. So the club takes issue with the reliance on the master's rights, and what the judge says there at 63 is, in the present case, it's the right of the master, not the club. The club was not charged with a criminal offence. It was only a civil liability which was established against it by the decision of the Supreme Court. Even if it were right that it is manifestly contrary to English public policy to recognise and give effect to a criminal conviction which arose when there had been non-compliance with Article 14.5 of the ICCPR, I do not consider that the same would apply to a civil liability on insurer such as that fined by the Supreme Court. So what he's saying is, even if it's manifestly contrary to English public policy to give effect to a criminal conviction where there's been non-compliance with Article 14.5, it doesn't apply where it's civil liability, because the relevant question then would have to be, does English public policy require a review by a higher tribunal of civil liability pronounced on appeal in civil proceedings? You see that at judgment 66. And even if that's not so, you need to show that it was manifestly contrary to English public policy to recognise and give effect to a judgment for a derivative civil liability, where that liability is established for the first time on appeal, where there is no right of appeal against the conviction of the person from whom the civil liability derives. So the club's case would require reliance on a different rule, which isn't part of English or relevant public policy. So that's the first point, the master's rights. The second point, failure to exhaust domestic remedies. You've seen what happened before the domestic courts, and it's not disputed that the club failed to bring a nullity application or an amparo appeal. It is, the master also didn't bring an Article 14.5 complaint. And to take you to, it's clear that the Constitutional Court can consider complaints of Article 14.5 of the ICCPR. We have that from the case of Moreno, which is in the bundle at tab 70. And if I could just here take you to the one Constitutional Court decision about which shows that these complaints can be raised in an amparo appeal. That's bundle 8, tab 75. So, page 2394. This is a decision of the Constitutional Court. 2394. At A, the appellants were acquitted by the Barcelona Criminal Court. Then over the page, 2395, complainant filed an appeal, which revoked the sentence of the criminal first court, finding the appellant for amparo guilty of a corporate crime and sentencing them to 6 months in prison. The appeal decision confirmed the statement of proven facts in the lower court's ruling, which it maintained unchanged, arguing that the succession of facts could be used to prove both the abusive nature of the corporate agreements and the wrongful intent of the plaintiffs. Then, at the bottom of that page, the appellants claim that their rights to a fair trial have been breached without observing the guarantees of immediacy in respect of the adversarial principle that should govern the assessment of evidence in the second instance. And you then see at page 2405, at page 2403, you see the case law that's cited by the club about new factual findings, the middle paragraph. And then at 2405, you see, to reach these conclusions, it was argued that various factual matters, likewise it has not been demonstrated in the appeal, although the declaration of proven facts in the lower court was confirmed, upheld without modification, the appellants were found guilty without holding a public hearing, arguing that both the wrongful nature of the corporate agreements and the intent of the appellants could be derived from the succession of proven facts. The criteria of the contested decision that intent could be ruled because there had been previous negotiations for the dissolution that was not shared. This is because it does not lead to the conclusion that the agreement was not reached because the plaintiff did not want it. Intent derives from the fact that the decapitalisation of the company took place on the winding up agreements. Over the page, appellants contend the rights have been infringed since they were convicted in second instance without having been given an effective opportunity to address the appellate court, to give their personal version of the role in the acts in which they were charged by virtue of evidentiary activity which contained personal evidence. And then it's based on the proven facts of the sentence, which was set aside remain unchanged, based on a reconsideration of those proven facts, to derive from it both the regulatory element of the crime referring to the wrongful nature of the resolutions adopted and the subjective element. In other words, the divergence is not due to a legal dispute as to the extent to which the interpretation of certain elements of the offence could be extended, but rather bears on a factual dispute regarding inferences drawn from the facts declared to be proven in order to understand these elements as being proven. So we would say that is an example. Well, and you see at 2408, the writ of amparo is upheld, has decided to uphold the writ of amparo.
What does amparo mean?
Scope. Scope.
protection of fundamental rights.
Scope or protection.
And I'm sorry, the literal it means protection. The word
Yes.
itself means protection.
Are there other sorts of appeals to the Constitutional Court?
I'm told for human rights appeals, it's only amparo that is available.
No, but that wasn't my question. Does the Constitutional Court deal with other matters apart from human rights matters?
Yes.
Constitutional matters under the Spanish Constitution. So we're talking about amparo here because it's always a human rights question. But if it weren't, it would be something else.
That's right. It would be. It's just the relevant provision of the Constitution.
I think you were saying this case provides an example of or illustration of. You're going to summarise what you think this case illustrates.
Yes, it illustrates that you can have an amparo appeal upheld
On the basis of fresh findings.
where your complaint is, yes, the assessment that the second court has done when it produced convictions following an acquittal at first instance. And the complaint is in part about new factual findings versus legal classification, evaluation. So, you say the judge was right to say at paragraph 68 that the club could not be said to have availed itself of all the legal remedies available to prevent the relevant liability arriving, as it had not appeared in the Spanish proceedings at liability stage to contest either its civil liability or any breaches of its own rights, which that finding may have involved. But it also then didn't appear make a nullity petition or file an appeal, amparo appeal to the Constitutional Court, which could have succeeded based on that case. Then we also say that the judge was right to conclude that Article 14.5 did not represent a right recognised as fundamental within the English legal order. And even if it did, it would not qualify as relevant public policy for the purposes of Article 34.1 of Brussels, as it would not be regarded as falling within the limits within which member states may have recourse to the public policy exception. You have, I think, the points the judge sets out in his judgment about the Article 14.5 obligation having been obviously ratified by the UK but not incorporated into domestic law. And given the UK's dualist system, it is not therefore part of English law, paragraphs 55 to 56. The judge then observes that the optional protocol to the ICCPR, pursuant to which states recognise the competence of that committee to receive and consider complaints, has not even been signed by the UK. That's judgment 52. Not every rule of international law must be adopted as a principle of English public policy, even if it has been recognised as a peremptory norm at the international level. That's 57, and you've seen the cases on peremptory norms. And he says at 58, the club has pointed to no basis on which a rule in the precise terms of Article 14.5 could be said to be a fundamental principle, other than the fact that the UK has acceded to the ICCPR. That's judgment 58. Now, obviously, that is what I think has prompted the club's about turn to say that in fact this rule is part of customary international law, and that is why it's a fundamental principle in the English legal order. Can I briefly deal with some of the points that were made yesterday? You were given a note which identified a large number of state parties to the ICCPR, and 9, I think 10 reservations it was corrected to.
Germany was the extra one.
Germany was the extra one. And might I just say, well, that I think that the correction almost highlights the danger of doing this, you know, without the proper evidence below, etc. That number of parties apparently justifies the assertion that the rule is part of customary international law. You've got the point that it was the opposite was said below. We say there isn't, in any event, sufficient evidence before you now to accept that proposition. For example, an ICJ judgment making the point. You have well in mind the requirements, stringent requirements of customary international law, virtually uniform and consistent state practice, for that practice to be on the footing that there is a legal obligation to act that way. Importantly, for instances of state conduct inconsistent with the rule to generally have been treated as breaches of that rule. I wonder if we could just turn up Freedom and Justice Party, which makes these points.
Sorry, which case?
Freedom and Justice Party, which I think
Yes.
was in my learned friend's note yesterday. It's authorities tab, bundle 4, tab 27. Paragraph 15. So, paragraph 15, customary international law has to satisfy 2 requirements. There must be evidence of substantial uniformity of practice by a substantial number of states. Opinio iuris, general recognition by states that the practice is settled enough to amount to a binding obligation in international law. Then at 16, the court cites from Benkabush, which makes the same point about widespread representative consistent practice at the beginning of the quote. And then just after the reference to Nicaragua, the court does not consider that for a rule to be established as customary, the corresponding practice must be in absolute rigorous conformity with the rule. In order to deduce the existence of customary rules, the court deems it sufficient that the conduct of states should in general be consistent with such rules, and that instances of state conduct inconsistent with a given rule should generally have been treated as breaches of that rule, not as indications of the recognition of a new rule. What is clear is that substantial differences of practice and opinion within the international community upon a given principle are not consistent with that principle being law. And then what's the relationship with a treaty? That's addressed over the page, 21. In this case, there is the added feature of the relationship of customary international law with treaty law. Over the page, again, citation from Benkabush. Treaty may have no effect qua treaty, but nevertheless represent customary international law. Quotation from the ILC draft conclusions. A rule set forth in a treaty may reflect a rule if it is established that it codifies a rule of customary international law, has led to the crystallization of a rule of customary international law, and has given rise to a general practice that is accepted as law. But if one then looks at Benkabush, which is the previous tab, just to finish the passage that they've cited, because it continues in Benkabush at 948. At 947, you see the passage that's just been cited in the indentation. And then at 948, at the bottom, talking about a particular convention in issue there. However, it's not to be assumed that every part of the convention restates customary international law. Like most multilateral conventions, its provisions are based partly on existing customary rules of general acceptance and partly on the resolution of points on which practice and opinion have previously been diverse. It is therefore necessary to distinguish between those provisions of the convention which were essentially declaratory and those which were legislative in the sense that they sought to resolve differences rather than to recognise existing consensus. That exercise would inevitably require one to ascertain how customary law stood before the treaty. And we say that is key in a case like this, where if you look at Article 14 of ICCPR, 1 to 3 have been treated as, pretty synonymous with Article 6 of the European Convention on Human Rights. But if you look at 5, subsection 5, it's treated totally differently in the European space. So it is necessary to look at parts of the treaty when one is engaging in the exercise of are any parts of this treaty reflected in customary international law, because the position may well be different on some sections of an article versus others. Just turning back to Freedom and Justice Party, because a number of submissions were made about it yesterday. Just turning up my learned friend's note from yesterday. I think you were pointed to the fact that that case demonstrates that 36 states responded to a survey. I'm reading from paragraph 10 of Professor Webb's note on special missions immunity. 23 states indicated that they required, CIL required immunity. 5 said they might require immunity. 8 did not express a view. And the point I want to take from Freedom and Justice Party is that what it found striking was the lack of contrary practice in this case. 2 things. It focused on affected states, so states that were affected by special mission rules, and on the fact that there was an absence of contrary practice. So if one looks at paragraph 50, this is Ms. Staines' submission. A particular feature of this case is the lack of contrary jurisprudence or practice. That's page 992. And it's also, I think, made at 79, which is the court's consideration. That's page 998. Under the question, does customary international law require states to accord special missions core immunities, the court's conclusion. And then at the bottom of 79, no state has taken action or adopted a practice inconsistent with the recognition of such immunities. No state has asserted that they do not exist. Do not therefore doubt that an international court would find that there is a rule of customary international law to that effect. That's obviously not the case here, given Article 2, Protocol 7. Then at 82, in our judgment, we should be concerned with affected states. The states affected by this rule are primarily those who either send or receive and recognise special missions. There is nothing to suggest that any state affected in that sense has ever objected to the rule. We do not consider it as necessary to show acceptance of the rule by states which are simply not concerned with special missions because they do not receive or recognise them, and so do not send their own elsewhere. So that, I think, perhaps answers why they were looking at 36 there. And I'd ask the court not to be swayed by the fact that it's 174 or 75 or whatever it is here, because this rule is capable of affecting every state fair process rights. That's why the number is bigger, but the important question is still, is there sufficient consistent practice? In Spain's submission, when you have Austria, Belgium, Denmark, Luxembourg, Norway, and Germany, all civil law countries in the European space, prominent ones, taking a different approach, the argument that there is a rule of customary international law, despite their contrary practice, is an unsustainable one. Another point just on the evidence that you heard yesterday, there was a point in the note about, well, only some of these are reservations on the convictions to appeal point. In my submission, my lord and my ladies, it's necessary to actually look at the reservations. The reservations, when you look at them, indicate the need for evidence, because they all have very different wording. France, for example, I think it refers to limited exceptions to Article 14.5. There's no possible way of knowing how that plays out in practice, what exceptions are applied by France, without evidence. Can I take you to one last, I think it's a 2-page dissent in a judgment, but it's important because it encapsulates, I think, the reasoning that I'm trying to put across in a UN HRC case by a prominent American judge. That's Authorities 8, tab 67. And it's the case of Gomares Valera, which is one of the cases relied on by the club. If one looks at page 2280, this is a case in which the committee finds a violation of Article 14.5 in relation to Spain, but the committee member, Ruth Wedgwood, gives a dissenting judgment, and she sets out the committee's judgment in the middle paragraph, and then she says, to be sure, in the legal tradition of common law countries, an appellate court cannot disturb an acquittal below, and indeed to do so would pose serious constitutional questions. But in civil law countries, including such states as Austria, Belgium, Germany, Luxembourg and Norway, an acquittal by a court of first instance may apparently be vacated in favour of conviction by a second instance court sitting in review, and there may be no further appeal as of right from that second instance court. The International War Crimes Tribunals, created by the UN Security Council for the trial of war crimes in former Yugoslavia and Rwanda, also create the same capacity in the appellate chamber with no further right of review. 5 European countries cited above invented formal reservations, and then a citation from a judge from one of those war crimes chambers. Some of those statements lean towards interpretive declarations, i.e. they are worded as clarifications as to what the covenant is assumed to mean in the first place. In addition, the committee should take account of Protocol number 7 of the European Convention for the Protection of Human Rights, which came into force in 1988. Article 2.1 of the protocol guarantees to any person convicted of a criminal offence the right to have his conviction or sentence reviewed by a higher tribunal, but Article 2.2 of the protocol also notes, as an allowable exception to further appeal, those cases in which the person concerned was tried in the first instance by the highest tribunal or was convicted following an appeal against acquittal. Of course, the convention doesn't govern the committee's jurisprudence, but it's hard to imagine that 35, now 36 state parties, obviously it's a bigger number now, to that Protocol 7 intended to act at variance with any obligations under Article 14.5 of the ICCPR. In reaching its decision today, the committee has not paused to survey to what extent the practice of those 36 states or other signatories of the covenant may be at that variance with the standard we apply. In a matter so fundamental to the structure of national court systems in civil law countries, we should give some consideration to the views of the state parties as well as their widespread practice. So this is a vexed issue, my lord, between civil and common law countries, and it is not, therefore, my submission, the sort of obligation that can properly be recognised as a rule of customary international law. What is the status of the ICCPR domestically? There are various points made about English law. English law, of course, does not provide for appeals against acquittals at all. It's quite difficult to draw any meaningful analogy with English law, because the issue of higher review in that particular context doesn't even arise. And sweep up a moment to just sweep up any other points from the note. My learned friend referred to cases where ICCPR has been used to interpret English law. Paragraph 7.1, she refers to RT Zimbabwe. That is a case, if I could ask you to look at the paragraphs she refers you to, it is a case where not only is there an Article 14, not only are Articles 18 and 19 of the ICCPR relied on by the court, but so is Article 18 and 19 of the Universal Declaration of Human Rights, and so is Article 9 of the European Convention on Human Rights. So in my submission, it doesn't make the point that it's advanced for, because the court is there looking at a range of treaties for guidance, and here the Universal Declaration of Human Rights does not contain Article 14.5, and the European Convention on Human Rights is in different terms.
How are we doing for time?
I will. $10 minutes now.
And does Mr. Young want to follow? Or?
My lord, I'm going to make about 3 comments on the CLC note that came in this morning, and I'm going to tender some assistance in looking through the judgment of the Supreme Court in Spain, if this most illustrious court needs it. I get the impression from the questions asked by Lady Justice Andrews that it's already.
I wouldn't be misled into getting any impression, Mr. Young, if I were you. I would just make whatever submissions you think appropriate.
It's only if you, as a court, would feel any need for just going through the judgment of the Supreme
The only thing
Court.
I feel a need to do is to finish this hearing at 4:15.
Yes.
And for you to adhere to your timetable.
My
And your junior is just slowing down a bit, which is why I raised the question of time.
yes,
And I will just want to make sure that both of you will fit into the next half hour, because Mr. Hancock has to be given the opportunity to
Yes.
reply, and he's agreed, you have agreed that he should have half an hour for that.
yes, my lord, I hope I've indicated that I'm going to say next to nothing.
Very good. Well, that's fine. Next
If
to
it's of any
nothing.
assistance, my lord, I'm
So-
hoping not to need to use my half hour.
Well, I think
Hancock or otherwise.
we'll still give you half an hour, Mr. Hancock, and if you don't use it, we'll cheer.
Those are my submissions on why Article 14.5 is not part of English public policy. They are also most of my submissions on why it's not a relevant part of public policy because of the
Yes.
importance of the contrary provision in the
In
convention.
short, you say the judge was correct.
Yes. I don't know, my lord, whether I need to deal with the question of an Article 14.5 violation. The learned judge obviously didn't have the benefit of the committee's judgment, and we say it's not relevant because the obligation doesn't arise, and therefore
It's not a relevant obligation that arises, and therefore it doesn't have to go.
yes.
You can give us the reference to the decision.
I think I gave them to you already, the 2
Okay.
paragraphs which I say have a paucity of reasoning. And I took you to one of those constitutional court decisions to show that
This was factually wrong.
Amparo works, and that Amparo appeal was obviously the basis of the view that there is no relevant higher review provided for by Spain. I took you to the case at tab 75, and the case at tab 74 is in similar terms. So we say that the reasoning is problematic, and all the more so in relation to a treaty that hasn't been incorporated into English law, etc. So that leaves the final limb, my lord and my ladies, of the arbitrary and irrational allegedly conclusions, Article 6 and Article 1 of the first protocol. The judgment, again, has its three reasons for rejecting the complaint. The attempt to review the substance of the judgment, paragraphs 122 to 123. The not overcoming the strong presumption that the courts of the originating member state will have provided a procedure that's compliant. That's the Moronier point, and that was 125. And not availing, the club not availing itself of its remedies. I've covered a lot of this already, I think, in the course of my submissions. On availing, the club availing itself of its remedies, you have, the submissions are similar to under to the previous submissions, in that the club didn't appear at all those relevant stages. And it wasn't enough for the club to say that all these routes were pointless. I think the judge addresses this at 126, and he says, I'm not persuaded it's a sufficient answer for the club to say that a nullity appeal to the Supreme Court would have been pointless, because as the club contends, it would never have changed its mind. I'm not prepared to make that assumption if the Supreme Court's decision was as lacking in any rational foundation as the club contends it to have been. And can I just, there's one further Amparo decision which shows that an irrationality complaint has succeeded on an Amparo appeal, and that is 77.
Do we need to actually look at it? Can you
No.
give us the reference?
I can give you the reference. Tab 77, page 2442, and you see the acquittal of manslaughter at 2444, appealed at 2445, successfully on grounds of irrationality at 2456, 2458. So we say that the failure to exhaust remedies was, the failure to avail itself of remedies was an entirely proper basis for rejecting the complaint. The second issue is the challenge to the judge's finding at 123 to 124 that the Brussels regulation precluded him from reviewing the accuracy of findings of fact and law, which I think I've addressed you on. And the last point is the analysis, the judge's analysis of the club's argument on irrationality, which I think, again, to the extent that I'm making submissions on it, I have addressed you on. Can I just give references to, again, where those arguments are in the skeletons? The argument about what the precise irrationality was is at the club's skeleton, 14.5 to 14.6 paragraphs, and it's tab 17, the core bundle, pages 353 to 355, and Spain's response is paragraphs 33 to 36 of its skeleton, core bundle tab 19, pages 395 to 397. And if it's of assistance, the same paragraph references for the specific arguments made about new factual findings, in case it's helpful to have them in the skeletons, are at club skeleton 22.3, page 362, and Spain skeleton, paragraph 61, page 405. So there are an awful lot of limbs to the complaint, and I hope I've been able to illustrate how they all fit together. We do say that the judgment is a sound judgment, and that each of the three reasons given by the learned judge for each of the complaints was sound. we say that there's no basis for remittal. And for those reasons, there is no reason that the appeal should not succeed. There are independent bases for each ground, and each of those independent bases is sound. The club would need to show that more than one basis on each limb was satisfied in order to succeed on its appeal. Unless I can assist the court further, those are my suggestions.
Thank you very much, Mr. Patel.
My lord, I said I had two things to do. I have, in fact, three. I think the first is both uncontentious and nice, and it's to express admiration for all four juniors in this case who have developed submissions in an exemplary manner. And I, for my part, would
we
like
have
to contribute.
noticed that, Mr. Young, and we are very grateful for them. And indeed, we'll go further and say that it absolutely vindicates the decision that the Chief Justice and I made to encourage juniors to speak in big cases, because I'm sure it's a good opportunity for them, and it's been very valuable for us. So thank you all.
Thank you. I was going to say exactly the same thing, so I'm grateful. I hope the second
Completely
thing.
endorse it.
I'm sorry, my lord.
I completely endorse it.
Well, that's always a good start. My learned friend, Mr. Hancock, handed in a note on the CLC. I have only three comments to make. The first is that in summarising at page 2, paragraph 2(8), he engages in a summary which does not adequately reflect the article, and I wonder if I could ask the court to pick up the copy of the CLC convention, which
So
is in
you're looking at 2(8).
2(8), where my learned friend
Article
says
7.
claims may be brought against the insurer for the ship owner's strict liability. In such a case, the limit of liability of the insurer is automatic and set in the limit, and so on. Now,
What do you contest about that?
well, it's only that the wording of Article 7.8 of the
Which
Convention
is where?
is in Authorities C, Bundle 1, tab 11, page 0144. I'm just going to show your lordship what it actually says, particularly in the light of submissions made by my learned junior on availing oneself of domestic remedies, and also in the context of one question which your lordship posed to my learned friend. And it said 7.8 at 0144 says any claim for compensation for pollution damage may be brought directly against the insurer or other person providing financial security for the owner's liability for pollution damage. In such case, the defendant, that's the insurer, may, even if the owner is not entitled to limit his liability according to Article 5, paragraph 2, avail himself of the limits of liability prescribed in Article 5, paragraph 1. He may further avail himself of the defences other than bankruptcy and so on. So it's not actually expressed as an automatic right of limitation, it's expressed as a right to avail oneself. And there are different views in different jurisdictions as to what needs to be done to avail oneself. This was raised in the context of causation stroke mitigation before Sir Peter Gross, but this is in relation to a rather different issue. It's just that, for example, the French law, there's a Cour de Cassation judgment, which says that if you wish to avail yourself of defence, you have actually to appear and avail yourself of it. But I merely draw
this arises from a question I asked, so as to understand the circumstances in which the proceedings had been begun, really for the second part rather than the third part of the case. But we're not going to be descending into the details of the CLC liability or its nature. All I was looking to understand was what the club had done in relation to the proceedings in Spain
Yes.
and the circumstances in which it had shoved the money into court.
Yes.
And I now know that answer
Yes.
to that, and I'm certainly not going to be
No.
getting into the weeds of Article 7, subparagraph 8, or any other subparagraph.
No, my lord, it was merely that I wish just to put...
Yes, you've corrected them.
And paragraph 3, he says that on the 28th of May 2003, the owners submitted a document to the Spanish court in Corbucion, noting that the club had instituted the limitation fund on its own behalf and on behalf of the owners. I don't think you've seen that. In fact, it's only on behalf of the owners. The club instituted the fund on behalf of the owners. Now, there are two possibilities. If it instituted on its own behalf, then it's submitted to the jurisdiction. And if it's submitted on behalf of the owners, then it didn't submit, but it was only on behalf of the owners.
You say that's wrong.
I say that is wrong, and the document itself has not been provided to you.
Okay.
The last point...
Astonishingly, I actually noticed that.
I'm sorry?
Astonishingly, I actually noticed that when I read through it.
I don't find that in the least bit astonishing, my lord. But I merely make those points because my learned friend handed his note in, and I didn't feel that I would be doing the court any service by allowing them to go without at least a mention.
All good.
Now, my lord, the issue arises as to whether recognition of the judgment would be manifestly contrary to English public policy. And the point is made in relation to Article 36 of the regulation that you can't look at the substance. And I hope it's clear that we accept that you can look at the substance of the judgment in order to discern whether there is a relevant breach of human rights.
Miss Patel said that.
I'm sorry,
Miss Patel said
yes,
that.
absolutely. It's just where I'm starting from, my lady, with respect. So, if one is looking for a judgment which is arbitrary and manifestly unreasonable, this judgment portrays none of those characteristics. And if I may just summarise them, and as I say, I apprehend that my lady has, with characteristic care, read the judgment.
I think we all have with
Yes,
the judgment.
My lady,
Or uncharacteristic care on the part of Mr. Rowe.
my lady, I was merely addressing your ladyship. I have absolutely no doubt at all, but everybody has read this judgment very carefully. My lady, so you won't need any assistance, that it was all about the true construction of Article 325 of the Spanish Penal Code, what its ingredients were, and the Supreme Court identified those ingredients, what its mental elements were, and the Supreme Court identified what the mental elements were, and then considered whether the proven facts, as they called them, satisfied those criteria. And they have arrived at a perfectly rational conclusion as a matter of Spanish law that is amply reasoned. It is as far removed from an arbitrary and manifestly unreasonable judgment as it is possible to be. Whether it is the same result that would have been achieved in England is nothing to the point. I could give you references for those passages, but knowing that all three members of this illustrious court have read the judgment, I don't
We'll start reciting it to you in Spanish if you're not careful.
That should be an engaging prospect.
That would be.
So unless I can assist you with those references, I am going to say I have nothing further to add.
Thank you very much, Mr. Young. Mr. Hancock.
Thank you, my lord. Can I start going back to the proposition which I think Mr. Young has very kindly accepted, which is that this court is entitled to look at the judgment of the Spanish court in order to determine whether the requirements of Article 34 are satisfied. So the statement, if it was intended to be a statement on the part of the judge that effectively the judgment of the Spanish court was unreviewable, it is wrong. The second question, obviously, is the standard in accordance with which this court is entitled to review that judgment. And I made my submissions on that yesterday. The question is whether the judgment is outwith the bounds of reasonableness. It's not for this court to say we disagree, but on the other hand, if the judgment is outwith the bounds of unreasonableness, then this court can say so and can refuse to enforce the judgment. The third point that I would make is that one of the bases upon which the court can review the judgment is to decide whether there has been a failure to comply with the provisions of the European Convention on Human Rights and with Article 47 of the EU Treaty. And if one asks, well, how does one know that? The answer to that is that that's what Kronbach says. Kronbach was a case which did involve a breach of the of fair trial requirements, and in Kronbach then the court decided there had been a breach of fair trial requirements, and that in those circumstances the judgment should not be recognised. That's paragraph 40 of Kronbach, so that we know that as a matter of the construction of the regulation, then the regulation says, A, you can review the judgment, B, you're doing so in order to decide whether or not to give effect to one of the provisions of Article 34 and therefore refuse recognition, and C, one of the grounds upon which you can refuse recognition is because there has been a breach of fair trial rights under the European Convention or the EU Charter. So the question that then arises, D, for this court, is on a proper construction of the judgments of the Spanish Supreme Court, has there been such a breach of human rights? And in order to answer that question, then your Lordship and your Ladyships obviously have to look at that judgment. I have taken you through the judgment of the Provincial Court and the judgment of the Supreme Court with wearying length, but although my account was wearyingly lengthy, the point is really a very short one. And the point is simply that the Supreme Court made factual findings which had not been made by the Provincial Court, which it is not open to the Supreme Court as a matter of the Spanish Criminal Code to the Supreme Court to do.
Even though it said it wasn't doing that,
Even
though the highest court said it hadn't done that.
Absolutely. And there actually we get on to further limbs, because if in fact it had done that, then we get on to exhaustion of remedies and the like. But the question for this court is, even though the Spanish Supreme Court said that it wasn't doing that, is it right that the Spanish court didn't do that? Now let me test that by reference to an example that my Lady Justice Andrews put. That is to say, where you, if you like, reclassify an offence by looking at the facts as found and saying that the inferior tribunal has held that that's negligence, whereas I think that's recklessness. So applying the legal test to the facts as found, not changing the facts as found, but applying the correct legal test to the same facts, I would reclassify that offence as an offence of recklessness rather than negligence. The difficulty in this case is that the provincial court had found that the master had no knowledge and could have had no knowledge of the defects with the vessel, because the provincial court held the only people who could have had knowledge of those defects were class. So, with great respect, I would submit that it was simply impossible for the Supreme Court, by virtue of a process of reclassification, to find that the master not only should have known, but did know about the defects with the vessel. That's just wholly contrary as a matter of a finding of primary fact as to the knowledge of the accused. And that is profoundly unfair and contrary to fair trial rights. The point is then compounded because the accused, firstly, isn't heard, secondly, has no right of appeal. But remember that the Supreme Court dealt with this in half a day. The provincial court dealt with it over 9 months, listening to hundreds of experts and hundreds of witnesses of fact, as Ms Patel has pointed out by reference to the UNHRC reports. So the suggestion that the Supreme Court was simply reclassifying the point.
The US Supreme Court holds hearings for half an hour, but I don't think people say that they don't think about it.
I wasn't suggesting they would, but insofar as it is suggested that in the course of that rather short hearing, not hearing from any of the witnesses, not hearing from any of the experts, the Supreme Court could effectively rewrite the experts' reports and hold that what the experts had said and what the provincial court on the basis of what the experts had said was wrong. I would submit is simply unsustainable. And the court has my points. There are the two essential issues. One is causation. They found that there was causation, matter of fact. The second is knowledge on the part of the master. They found that the master did know. He caused the loss intentionally or recklessly and with knowledge that, that the loss would probably result. So a complete revisitation of the mental element of the crime. And then thirdly, to put the tin lid on it, then the Supreme Court made those findings against the owners as well. So in circumstances in which the provincial court had made no findings at all about the owners, save for its holding that, and I quote, nobody could be aware of the existence of as serious deficiencies as to produce an imminent wreck, with the only caveat in relation to that being that the only people who might have known about that were the Classification Society, ABS, who incidentally Spain sued in the United States. So it's, as I say, it's a simple point, my lord, my ladies. The fact of the matter is that on analysis, and it doesn't need to be a very deep analysis, the Supreme Court did actually effectively reach conclusions which were wholly inconsistent with the factual conclusions of the provincial court, contrary to the requirements of Spanish law. Let me then go back to 2 or 3 short other points. One is the suggestion that this was in the context of criminal proceedings. The answer to that is that the prohibition in relation to making new findings of fact applies just as much to civil proceedings as it does to criminal proceedings. The Supreme Court itself recorded that because in the civil section of its judgment, it made reference to the fact, and that is at page 137 internally of the judgment, where they consider civil liability and they say we have to address the question from the point of view of the facts declared proved in the impugned judgment and the statements of a factual character included in the legal grounds. So exactly the same prohibition on reopening facts applies in relation to civil liability as it does in relation to criminal liability. Secondly, then in relation to the club's rights and the master's rights, then the suggestion is made, well, the club is seeking to rely on the master's rights, not its own. There are a number of answers to that. The first is that the master did indeed, in relation to, sorry, this is a separate point. The first point is that whilst the club does rely upon the breach of the master's rights, it also relies and is entitled to rely on breaches of its own rights under Article 1, Protocol 1 in particular, because the impact of the court's decision was to deprive the club of its property in breach of Article 1, Protocol 1. The next point I need to address is the suggestion that essentially all of this is ruled out of court in front of this court because of the proceedings which went to Strasbourg. Strasbourg is not an apex court. So it's not a question of the matter being ruled out of court in this court. I think in fairness, Ms Patel did not suggest...
She said it was Section 2.
I think she did not suggest that the matter was determined...
She said we were obliged to take it into account under Section 2 of the Human Rights Act.
That's right.
Which we are.
That's right, Molly. And that's why I say she was very accurate and fair in the way that she put it. It is something that the court is entitled to take into account. It's not binding on the court. And in a sense, the force or otherwise of the Strasbourg ruling depends upon what it is that the Strasbourg court said and why it said it. The difficulty there is that the Strasbourg court said nothing.
Well, it sort of said stuff after being pressed.
Well, its actual ruling, it didn't deal with, in terms, any of the points.
I mean, it struck out the claim, really. It struck out the claim.
It did, but it didn't actually say why it was striking it out. So there were all of the points that the master, and of course it is the master who was taking these points. The master made all of these points. The Strasbourg court, in 2 lines, said no, we're not hearing this case. And the question for this court is, to what extent is there anything that it can sensibly take into account in those circumstances when there's simply no indication as to why the court was...
Well, there is an indication as to why. I mean, I suspect the whole thing is slightly shrouded because they got so excited, or everybody got so excited about the suggestion of bias by the Andorran judge. But if they hadn't got quite so excited about that and instead concentrated on the substance of the matter, it does say that I can't remember the precise words, but they do say that the thing was considered in full detail and all the facts were looked at, and it was decided that there was no substance no validity to the allegation that there had been a breach of fundamental rights.
It wasn't obvious that there was a breach of the... in other words, it wasn't sufficiently obvious on a prima facie basis that you had a case, or that the master had a case.
Well, I think it went... I may be wrong, my recollection may be wrong, but I think it went a little bit further than that, and I wrote it down. I think it said, the correspondence anyway is at page 309 in the core supplemental bundle. It might be just worth turning it up so you can address specifically what they did say.
First point, my lord, I would make is what the document I think that your lordship is thinking of is the document that was sent after the actual decision.
Yeah, no, that's a fair point. That's a fair point. I just wanted to be absolutely clear as to what they actually said when
Yes.
pressed.
And what you have to bear in mind is this is the court registry that is actually saying this. This is not the court. This is the court registry. And you recall actually what they said is they said, we've got this process which we adopted because there was this big backlog with cases in Strasbourg. As a result of having to deal with things rapidly, then we produced decisions which were in standard format, which were only 2 or 3 lines long. They didn't then go on to say, and the reasons why this particular decision was rejected was because A, B, C, D, E.
Well, what it says is at page 327, mercifully, in the core supplemental bundle, which is the only one that has correct numbering, so 327 in both.
Yes.
The decision in the present case, following the new practice since 2007, is a reasoned decision specifying the grounds of inadmissibility as manifestly ill-founded after a full analysis of the facts of the case within the meaning of Article 5.3. The court declares a complaint manifestly ill-founded for reasons relating to an examination on the merits of the complaint. The grounds for inadmissibility are therefore not procedural, for example, non-exhaustion of remedies or time limits. It's true that the use of the term manifestly may cause confusion. If taken literally, it might be understood to mean that an application will only be declared inadmissible on this ground if it's immediately obvious to the average reader that it's far-fetched and lacks foundation. However, it is clear from the settled and abundant case law of the convention institutions that the expression is to be construed more broadly in terms of the final outcome of the case. In fact, any application will be considered manifestly ill-founded if a preliminary examination of its substance does not disclose any appearance of a violation of the rights guaranteed by the Convention, with the result that it can be declared inadmissible at the outset without proceeding to a formal examination of the merits. So it is a real strikeout.
And my lord, my ladies, then, as I've said, the court has to take that decision into account. Then what I would submit is that you then need to look at the grounds on which the application was made, and you need to ask yourself, if you adopt the language that we'd adopt in this court, do those grounds display a prima facie case of breach of the convention? If the position is that the grounds don't, on their face, display a prima facie case of breach, then actually the court will strike it out. But if, in fact, when you look at the grounds, then they do display a perfectly adequate set of arguments in support of breach, then I would submit this particular decision, reached pursuant to this type of standard form procedure, 3-line decision, is not actually a good ground for holding that a decision of the Spanish court, which by definition, in a sense, if you've got to this stage of the analysis...
Well, that's a perfectly fair point. It's a different point.
Yes.
You're fully entitled to say whatever they may have thought. These were proper points.
Absolutely.
Yeah.
And my point is that if you've got to this stage of the analysis, and therefore have concluded that on the face of it, it's a judgment which was unfair,
And
then
the fact
actually
that the ECHR...
the fact that that this tribunal, in its very, very short, unreasoned decision, has said what it said, shouldn't put you off giving effect to your conclusion that it's unfair.
Yeah.
And I should also remind myself, probably more than the court, that Lord Neuberger, in a case which is in the authorities bundle, sorry, in a speech which is in the authorities bundle, it's in authorities volume C, tab 85, at page 2529. Yeah, speech. No, it's
Talk.
yes, it's an extrajudicial
Right.
speech.
Which paragraph?
It's at paragraph 31, isn't it? So 33 of the speech. And he sets out, indeed, going down to 35, he sets out the defect at 35 in particular. He says that he wonders whether UK judges have sometimes been too ready to assume that a decision, even a single decision of a section of that court, represents the law according to Strasbourg and accordingly to follow it. That approach is attributable to our common law attitude to precedent and to our relatively recent involvement with Strasbourg. I think we may sometimes have been too ready to treat Strasbourg court decisions as if they were determinations by a UK court.
Can I suggest that he said that after he ceased to be president of our Supreme Court?
Your Lordship may well be right, but my only point, as you will have seen,
We all
is
become
that,
less cautious after we cease to be judges, apparently.
sure, that's right. But I do rely upon his words.
It's a point that didn't need to be put in the mouth of Lord Newburgh, actually.
The next point I need to take you to is in relation to Diageo.
Yes.
And in view of the time, can I just give you a couple of paragraph references for the first of my points, and then actually draw your attention to one factual side of Diageo. You were referred, I think, to paragraphs 43, 49 and 50 of the judgment in Diageo. I would draw your attention to the fact that in each of those paragraphs the word solely appears. And this goes back to the point I started with, that you can't actually, as it were, refuse to follow a decision of another European court just because you disagree with it. There has to be a more fundamental problem than that. Secondly, in relation to Diageo itself, you have to bear in mind that the rule of law that was there in issue was a rule of European Union law. Indeed, in that particular case, then the court decided that that was not a fundamental rule of law. There are certainly the paragraphs that Mr. Patel took you to, which may look as though they are drawing a distinction between public policy as a matter of European Union law and public policy as a matter of national law. In fact, as we discussed in relation to topics last week, there is this two-stage process of asking whether something is a rule of public policy as a matter of national law, and then asking whether there is a limitation imposed by European Union law on that rule of policy, which depends upon whether or not the Cronbach test is satisfied. Just for your note, and this, I know this is a point that Lady Justice has, then you refer to the Maronier case and the presumption that foreign courts will actually comply with public policy. As my lady said, that is a presumption. It is not an irrebuttable presumption.
Well, that's what the court said.
Indeed,
Maronier.
because
I was
in
just quoting it.
Maronier they held that it was rebutted. And I then go back to the judgment, and the judgment at paragraph 124 which is where the judge reached his conclusions to the attack on the Spanish Court of Appeal decision. And my Lord the Master of the Rolls pointed out that he had actually quoted bits and pieces from Diageo elsewhere in his judgment. When we then get to this paragraph, this is the paragraph in which he relies upon Moroni, but without relying upon any of the previous. And he then, in bold, says that there can't be a review of the accuracy of the findings of law or fact made by the court of the member of state of origin. He then says that that doesn't mean that there can't be cases which are unenforceable because of manifestly unreasonable or arbitrary, and he gives the examples of the lack of legal, the complete lack of legal reasoning, or the result being manifestly made to depend on a matter which has nothing to do with the relevant law or facts, and differentiates that from a situation in which there is a process of fact-finding and legal finding. Now, the court has my point that that's an unreal distinction. If actually there is a finding, if there is a process of legal reasoning, but that process of legal reasoning is obviously wrong, that is just as much reviewable as where there's no process of legal reasoning at all. But more importantly, for present purposes, if one then looks at what he
Well,
then
it's not that
done,
you have to say it's wrong, Mr Hancock. It's got to be said that it's so wrong it's perverse.
yes, I accept that, my lady. As I put it, it has to be a wrongness of a higher order, if you like. But the point that I'm making here is that what actually happened here is that the judge declined to even enter into that inquiry. If you look at each of these 4 subparagraphs that he sets out under this heading, then he says actually, he sets out what the relevant question is, and he says that in relation to each of these, it is clear that the club's criticisms are invitations to the court to review the accuracy of the Supreme Court's finding of law or fact, and then he doesn't review those findings of law or fact. He says each involves a criticism of the findings of fact or law. So effectively he's saying, if you're criticising the findings, I'm not going to consider your criticisms. And with great respect, that's not good enough. You need to actually go, he needed to go to the judgment, consider each of the criticisms. If you then go to subparagraph 2, exactly the same. He sets out the nature of the complaint and says this complaint accordingly boils down to a case that the Supreme Court was wrong to make the factual findings it did, which is an invitation to the court to review the accuracy of findings of fact. Now, if in fact the Supreme Court was wrong to reverse the findings of fact of the provincial court, which would be the case if it was applying Article 849.1 properly, you need to review the findings of fact of the Supreme Court and compare them with the findings of fact of the provincial court. You can't simply say, this is an invitation to me to review them and I refuse. The same is true in relation to subparagraph 3. He says at the end of that subparagraph, I consider that to be a finding of mixed fact and law, and the club's criticism is either an attack on the test applied or its application to the facts. Again, what he's saying is, I'm not going to go there. I'm simply not going to review the judgments. And exactly the same point applies in relation to his 4th subparagraph. The club's real complaint is that the findings which the Supreme Court made were ones which it was not entitled to reach on the basis of the material before it, and that, as I have said, I consider to be an impermissible invitation to review the substance of the decision. So in each case, what he's saying is not that I have reviewed the substance of the decision and it's perfectly legitimate, it's a perfectly reasonable decision. He said, right, reminded correctly, he's not said that the test of perversity on the facts of this case is not met. He's simply saying, I'm not going to review the judgment, which effectively is an application to the facts of this case of the bit in bold in his judgment, which is the portion from the regulation itself which does not take into account the approach as set out in Diageo. My lord, my ladies, then the next point is in relation to the new facts point. And in relation to the new facts point, can I just invite the court to look at paragraphs 84 to 86 of the judgment? Because again, this actually relates to the manifestly point. But again, great respect, then what the judge did here was erroneous. Because what he did here, as he said, I've considered the arguments made and the expert evidence given as to whether new factual findings were made on appeal. It is clear to me that there is at the least a bona fide and significant argument that no new material factual findings were made by the Supreme Court. It is not a case where, on an examination of the case, it is plain or obvious that there has been a contravention of the Master's fair hearing rights not to have new factual findings made on appeal. And he then actually goes through at paragraph 85 a consideration of the expert evidence of Professor Ortiz, who was the expert called by Spain. He goes then, having gone through that, he says that there was a reality and cogency of argument to the effect that there were new material factual findings, so as to make this case a long way from one where it's plain and obvious that fundamental rights have been infringed and that it would be contrary to public policy to recognise the judgment. So again, what he's doing there is he's saying, I've looked at the evidence of one of the experts. I haven't considered, on the face of it, the expert evidence on both sides. Rather than then reaching findings of fact based upon the expert evidence from both sides as to whether there have been new findings of fact, he simply says, well, it's not obvious on a plain reading of the judgments that there have, and there is a real argument to the contrary, as we see from the evidence of one of the experts.
But how could he actually decide that they had decided new facts without getting into the weeds of deciding the case for them?
Well,
I mean, all he's doing is saying, is it a perverse decision, or is it a decision that is obviously in violation, manifestly in violation of fundamental rights? And the answer is it's not, because there's a perfectly good argument put forward by Professor Ortiz to the effect that it's not on the Spanish law new facts. So it's, I mean, he's doing exactly what he said he was doing.
Well, it depends on what one means by doing exactly what he said he was going to do. We would say, for the reasons I've been through, that it is.
You say he was supposed to get into the weeds and decide whether Professor Ortiz was right or wrong.
Absolutely. And that's why he'd heard 5 days of expert evidence as to what Spanish law was. But in a sense, this is, if you like, a second order point, because he could actually tell just from a reading of the judgments, in the way that I have outlined, that there was that there were findings of new facts which were not permissible. That's apparent from a reading of the judgments. You have that point, but if and insofar as a court has then to address the question of whether, on the facts of the case, where the question is whether the court should be enforcing that judgment, then the judge needs to look at all of the evidence which relates to that question. It's not good enough to say, oh, well, it's an arguable case based upon one expert's views to the effect that there weren't new factual findings.
But he assumes, I mean, I don't want to get into the argument, but he does assume in that paragraph that the other expert had put forward an equally arguable case, that there was a finding of new facts. I mean, that's the premise on which he's looking at it.
I'm not so sure that is right, with great respect, my lord. When one gets to paragraph 86, he's only looking in all of these sub-paragraphs at the evidence of one of the two experts.
Because he's looking to see whether it's plain and obvious that there's been a contravention of the human rights. Not because he's assuming that there's no case at all on your side.
Well, in my submission, that's actually what he did do. He didn't properly determine whether there was a on the totality of the evidence before him. He didn't determine whether there were new findings of fact, and this goes back to his analysis as to what the word manifestly meant in the regulation. And his analysis was that it has to be obvious without actually the need to argue the point. Because of that analysis, he said, as long as one party is saying that the judgment is all right, that's sufficient for me. And my submission. And as Tan reminds me correctly, then the example I gave yesterday in relation to the bribery, the judgment obtained by bribery shows that. So, my lord, my ladies, then, short point on the amparo appeals. Ms. Patel says, oh, well, and nullity appeals. She says, well, there are cases in which there have been successful appeals to the Constitutional Court and to the Supreme Court. There have been lots of cases where there haven't been successful appeals. And you've seen from the cases referred to in the skeleton arguments that Ms. Patel took you to, which are in one of the footnotes in our skeleton, that Spain is a bit of a serial offender in this regard. And if one asks on the facts of this case whether going to the Supreme Court would actually have been an effective remedy, to use the words from Diageo, then my answer to that is clearly not. And actually the clearest way of telling that is because the master did go to the Supreme Court and the master got short shrift on his nullity application. Perhaps unsurprisingly, because it was the same constitution of the Supreme Court that had heard the first Supreme Court appeal. That is the Constitutional Court. Constitution. I'm told that I may not have been clear, and I apologise for that if I wasn't. I was talking about the nullity appeal to the Supreme Court, which would have failed because of the fact it was the same Supreme Court that had made the decision in the first place, and one can see that from the fact that the master's nullity appeal failed too. Then there is the further appeal, as has been rightly pointed out, namely the amparo appeal. The probability there is that it would have been rejected out of hand because the case did not raise a question of constitutional significance. But even if that was not the case, the question then would be whether on the amparo appeal there was any real possibility that the Constitutional Court would have come to a different conclusion from that which the Supreme Court did. And we are, in any event, talking about a world in which it is said that the club should have submitted to the jurisdiction of the Spanish courts in order to be able to pursue appeals from the Supreme Court to the Supreme Court and thence to the Constitutional Court, notwithstanding the risk that they would thereby be submitting to the jurisdiction, a risk that Sir Peter Cross held they did not need to subject themselves to. I do now understand the point that my learned juniors are making. I believe they'll tell me if I'm wrong. The owners did not appeal to Strasbourg. The owner's complaint was in relation to the CLC point, willful misconduct, and it was because of the CLC point, as in the willful misconduct breach of the CLC limit, that the club became liable for the full voluntary insurance limit. I'm told that I'm still misunderstood the point, so I'm going to ask Miss Tan to explain it to you.
My lord, my ladies, it's just a short point about whether or not the inadmissibility decision from the Strasbourg court on the new facts ground knocks out CLC ground, which was a point which my friend Mr Patel made.
Knocks out which one?
The CLC ground,
Mm-hmm.
which was a point that Mr Patel made. The answer is twofold. Firstly, as my learned friend Mr Hancock has said, the inadmissibility decision was unreasoned. So actually we don't know whether this specific argument, for example about causation, which is the overlap point between the two grounds, whether that specific point was rejected, or whether it was rejected for some other reason. That's on the master. The second point is, on any view, the Strasbourg application said nothing about the owner's liability and any factual findings about the owners. So this point cannot be, on any view, an answer to our complaints about arbitrariness vis-à-vis liability of the owners.
Thank you very much.
My lord, with apologies for having taken more than my half hour, then that concludes my submissions.
Not sure you did actually, but anyway, thank you. Well, that concludes the hearing, I think, if I'm not mistaken. So it only remains then for me to thank all counsel and solicitors for the presentation of the case, save for the matter of the bundles. But it's been an extremely intense 7 days and a very interesting one, and we are very grateful for the assistance that we've received from all of you, and we will, you may be assured, give the case our anxious consideration, and you should not go away thinking that anything we may have said in argument discloses where we will end up, since we have not yet ended up anywhere. It's a difficult case. We will go away and write our judgments when we write them. I'm not going to give an extempore judgment this afternoon, which may surprise you. When we hand down our judgments in the usual way, this case is peculiarly politically sensitive and difficult, and it will be all the more important if we decide to give you the opportunity to comment on them or suggest typographical corrections, that the limit of the number of people looking at the judgment is very low indeed. And those limits are almost certainly going to be confined to counsel and one or two named solicitors, not clients, I'm afraid. If clients are to be shown the judgment before release, it'll be on a 2-hour basis on the morning so that they can deal with any press or publicity concerns they may have. I suggest you work out a very tightly controlled regime amongst yourselves and send it to us for our approval. I suggest you do that long before you hear that the judgment is ready. The judgment may obviously, or judgments may take some time. When you get the judgments and an opportunity to comment, if you do, that's not certain, please confine yourself to typographical questions, not to re-arguing the merits, because I think there is a tendency amongst those in court not to give up. Dogs and bones do come to mind. So please confine yourself to that and use the judgment to agree the order that you think it's appropriate to make and to agree costs. If you can't agree costs in the order, we will deal with that in writing. It'll take some really important matter to persuade us to sit again to hear any such arguments. It shouldn't be necessary. I know the case has been complicated and there are numerous appeals, but if I can put it this way, we have got the points. So thank you all very much. It's been a pleasure, and I wish everybody a very good evening.